This is John Watts. Thanks for watching this video. I'm a consumer protection lawyer in Alabama, and there's a great question asked here by Easy Bake Barbecue. It says, hey John, I've had a second attorney tell me that all Midland, that would be Midland Funding, Midland Credit Management, needs is a bill of sale to prove they own the debt. Please explain. So let's kind of take a step back, and I want to approach this from a couple different ways. One is kind of the legal aspect of it, and then another is this proof idea. So maybe the legal aspect is sort of, what does your state rule? Okay, because what your particular state says may be different than the state over here or up above or below. And so you really have to know, what does your state say? And then sometimes even within a state, there'll be differences between counties. And maybe even within the county, differences among the judges. So you want to kind of start off broadly. What does your state say? And then if you can tell, what does your county say? And then what does your judge? Now, I'll just tell you, in Alabama where I practice, it's pretty consistent. But for example, there's one county, and it's south of Birmingham. It's called Shelby County. And the judge that was there, a judge named Judge Allsbrooks and now Judge Krausen, they've been very, very diligent about, when dealing with assigned debt, these debt buyers who claim to buy debt, how do they prove that they own it? And so this is just known. I mean, this is not anything official, but just all around the state, people talk about, well, now we're going to follow the Shelby County rule. Okay. Now, other counties don't have to, but most counties do. Okay. And so there may be something like that in your state. And typically within a county, the judges are going to be pretty consistent, but not always. Now, let's think about it a different way. Just start with a very simple idea. Somebody suing me for a debt, it just makes sense that they're going to have to prove that I owe the debt and that they own the debt. Okay? See, I can prove that you owe money on your house, but that doesn't mean I get to sue you for it. Even though I can prove you owe it, but I'm not entitled to it. I can prove you owe on your car, but I'm not entitled to it. I can see where I'm doing. So it's just a basic idea that a company coming along, like Midland Funding, Midland Credit, this debt buyer, I never borrow money from them. I don't have a credit card that says Midland Funding. I didn't take out a personal loan from Midland Funding or Midland Credit. Midland Credit didn't fix the air conditioner on my car or my house or repair plumbing, or they didn't do any of that. They say that they bought a debt. Okay, prove it. Prove that you bought the debt. Prove that you own it. And even this attorney that you met with, the second attorney, they're also saying, well, they have to prove they own it. They just say, well, they can do it with this bill of sale. Okay? And that's frankly where a lot of people like to stop. And maybe in your state, that's all they have to do is just like a bill of sale, no matter what it says, no matter if there's any legitimacy to it. Maybe just if it says bill of sale, everything is good. I doubt it. Okay? I mean, I could put bill of sale that, Elon Musk bought, a bottle of water from me for $10 billion. Now, he's got the money, I suppose, but that may not be true, okay? It may not be accurate. So in most states, they're going to have to prove that they own it, and if they're waving around a bill of sale, well, let's look at the bill of sale and see what it says. Now, I think I did a recent video, or maybe it's been a month or two ago, about like an LVNV bill of sale. But the point is, you read those, typically they're 1 or 2 paragraphs, and they'll talk about, here's the seller, okay, typically the original creditor, although you do have to check because it may be a debt buyer. So it may be the original creditor sold it to a debt buyer who sold it to a debt buyer who sold it to Midland, okay? But let's sort of give them the benefit of the doubt, say it's original creditor and Midland. So say, hey, we're the seller, Midland's the buyer. Okay. So what we know is that the seller supposedly sold something to Midland, and we have a date, at least the contract was entered into. Well, what did they sell? Well, it typically will say there's some exhibit. Or you look at the purchase agreement. Well, where's that exhibit that has the 10,000 loans in it? They go, oh, well, that's secret. We can't reveal that, but we'll give you a redacted version that just has your information. It's okay. Well, without me seeing sort of the real thing, I don't know if you redacted it properly. Okay. But let's just assume that they can get over that hurdle. Almost all of these say that there are no representations made. Okay, no warranties, no recourse. In other words, we're not promising, we, the original creditor, are not promising to the debt buyer that any of this information is accurate, except as set forth in the purchase agreement, the credit card purchase agreement, the forward flow agreement, whatever that it's called in your particular bill of sale. So when we look at that, we say, okay, original creditor sold something to Midland, supposedly it was a bunch of accounts, but we really have to look at the purchase agreement to see what was sold, what promises were made, what representations, what limitations. I mean, did they sell stuff and say, but you cannot file suit on this? Now, the collection lawyer goes, that's crazy, that's outrageous. I mean, if you sell it, they can do whatever they want with it. Really? Is that true when we buy a house? So if I buy a house in a neighborhood that has a homeowner association, I can park cars in my front yard. I can paint the house pink. I can do anything I want because I own the house? No, because when I bought it, there were limitations. Okay? I can't put up a 20-foot tall fence. Maybe if I'm changing the door, I have to get approval by the HOA. Now, if we live out in the country, yeah, you don't have that. But my point is, just because you buy something doesn't mean you get to do whatever you want with it. It means you get to do whatever you want with it unless you agreed otherwise. Well, in this purchase agreement, if we look at the purchase agreement, what if it says, hey, these documents are accurate, the accounts we're selling you, we stand behind them 100%, but because of customer relations, we do not allow you to sue on these accounts. You, Midland, promise you will never sue on these. Now, they would go, Judge, that's outrageous. There's no way we would agree to that. There's no way the purchase agreement says that. Prove it. Let's look at the purchase agreement. Oh, no, we can't do that. I mean, Judge, just trust me. The purchase agreement does not say that. To which we respond to the collection lawyer, so you've read it? Well, no, they won't let me look at it, but somebody at Midland told me that it doesn't say anything crazy that would be bad for us. Okay, so now we're into hearsay. But that person in Midland that told you that, had they read it? Well, no, they're not allowed to read it either, but they were in a meeting where somebody said that they once talked with somebody who had read one of these years ago, and trust me, it's all good. It's all good for Midland, nothing helpful for the consumer. Now, obviously I'm sort of exaggerating it, but trust me, I've been in court enough that it's not really exaggerating it. But you see why you have to look at that purchase agreement. I don't know what it says. And when they go, oh, we're keeping this so secret over here under lock and key, we won't let anybody look at it. Well, if it was so good for Midland, why won't they share it? There's got to be a reason. They go, oh, well, it's top secret. People would know what we bid. You can black out the amount you paid, okay? But there's something that they don't want the judge to see, okay? And that's the argument. So if somebody says, oh, well, all I need is a bill of sale. Well, maybe. And maybe the judge doesn't care anything about your arguments. I mean, look, there are some bad judges that won't listen. I mean, there are judges that will say, all right, you got 2 minutes for the whole case. And then other judges on a case that should take 10 minutes will give 2 hours. That's sort of luck of the draw. That's why we kind of harp on you really have to know your judge, okay? So, but if you have a fair judge, that judge may be used to just saying, well, you got the bill of sale, you're good. And And look, some of the judges that I think are good, that would be sort of their natural inclination is, got the bill of sale, what else do you need? But when we've started explaining it, well, Judge, here's why. Because maybe that purchase agreement, as some do, disclaim, in other words, reject any accuracy of any of the records sold. That makes a big difference. When they come into court and they go, look, we got the statements. These have to be accurate. We go, well, show us the terms and conditions that give us the interest rate. They go, well, we don't have that. But I mean, look, these things are solid gold. They're absolutely accurate. But then if the purchase agreement over here says, we're selling it to you as is, we make no promise that anything is remotely accurate. You see, that's a contradiction. And so when we explain that to the judge, a fair-minded judge says, wow, okay, it could be, they ask the collection lawyer, what was the purchase agreement says? Does it have that kind of disclaimer? And when the lawyer goes, no, it doesn't, and we say, Judge, has he even read the purchase agreement? Because normally they won't let the collection lawyers get within 100 miles of the purchase agreement. He goes, well, no, I haven't read it, but I'm sure it does. Okay. Well, now the judge, see, their curiosity is piqued. Like, well, what's in there? And then we talk about, does it limit the ability of the purchaser, Midland, to sue on this? Well, if it does, then that may give us a defense that they're violating that. Now, it gets into some legal stuff, or what's called a third-party beneficiary. Depends on how it's worded. If it's worded that we do not want our customers sued because we want to maintain good relationships with them even on defaulted debt, well, then I would argue, yes, we are the beneficiary of that. And we should be able to enforce that Midland cannot sue us. Now, again, the lawyers will go crazy. Midland will go crazy saying we would never agree to that. Well, how do we know? If nobody's looked at the purchase agreement, how would we know that? We have to see the purchase agreement. So I'm not saying that, every judge will accept this and that every fair judge will rule in your favor. There may be a judge who's very fair who looks at this and says, you know what, I don't think this is required. Okay? But I'm telling you that these are some legitimate arguments you can make. Now, when we get into sort of the legal stuff, we get into, the completeness doctrine. If you're going to have one piece of a contract, like one page of a 100-page contract, we need the rest of the contract. In a personal injury case, when I'm putting in evidence about medical records and surgeries for somebody who maybe has been horribly injured, in a tractor-trailer collision or something like that, and I say, well, I just want to put in this one page of medical record, maybe one paragraph. Well, the other side goes, who is this clown? All the medical records come in. And the judge would say, of course, John, all the medical records come in. If you open, the expression is if you open the door. You can't just crack it a little bit. If you open it, the other side gets to open it all the way. Well, they want to put in the bill of sale. Well, where's the rest of the document? See? So the completeness doctrine. They want to talk about, well, here's what the contract says. Here's what the purchase agreement says. This is what the terms and conditions say. Well, see, now we're talking about something. Why don't we just look at the document? That's typically called the best evidence rule. Don't tell me about the contract. Show me the contract. If the issue is whether or not two people are married. So not to go down too much of a tangent here, but like in Alabama, we have a unique wrongful death statute. So if somebody's killed due to the negligence of somebody else, then the person who is the personal representative is the only person that can bring that lawsuit. I'm excluding minors, children right now. But the whatever money's recovered passes as if the person who died had no will. It doesn't matter if they have a will. We don't care. It just passes, some will go to a spouse, some will go to kids. So what you have are people that, when somebody's died, they sort of come out of the woods and say, oh, well, we were married. Really? Because see, if they're married, now they might get to control a lawsuit. They might be entitled to half the proceeds or maybe all the proceeds. And so, if we're in a battle over that, well, were you really married? And they go, I was married. Well, okay, that's cute to say that. Where's the proof? Where's the marriage license? That would be a good start. And this is where they typically, oh, well, we were common law married. So again, I'm not getting into all that. But my point is, we have a principle, a concept when we're in court. Don't tell, but show. Okay? Don't tell me about the contract and describe the contract and say, well, I think page 3, section 4, or maybe it's page 7, section 6. Which one is it? I don't know, but it says something kind of like maybe sort of about that. No. You're suing under a breach of contract. Show me the contract. You're claiming to buy the debt. Show me the contract where you bought the debt. So, again, not saying that this is impossible to lose or anything like that. And you have to know your judge. You have to tailor the argument to the judge. And frankly, when you're in sort of the heat of the battle, in that moment, you got to read the situation. And you may go in there with 30 minutes of stuff and realize this judge ain't going to listen more than 3 minutes. Got to cut it down. Or maybe you go in for like 2 minutes and the judge is like, hey, I got an hour. Let's talk. And so you've got to be able to understand and read the situation. And I don't know, maybe I'm rambling on here. Nobody is listening at this point. But if you are, hopefully this helps. Hopefully this gives you a little bit of insight of why it's so important to see that purchase agreement and why I feel that the bill of sale is not sufficient. And this is what, for, 2021? I don't know, for, 10, 15 years we've argued and, pretty successfully argued this. And I can't even tell you how many of these cases we've handled, 1,000, 1,500, 2,000 cases. I'm not sure. A bunch, just put it to you that way. And so again, no guarantees in life, but hey, it gives you a good argument. And when you can lay it out for the judge so that the judge understands and she goes, oh, okay, I see why just the bill of sale might not be enough. We do need to look. So see, you're not necessarily convincing them what's in the purchase agreement. You're saying we have no proof without the purchase agreement. We have to look in there. So I'm going to wrap this up. Hope it's been helpful. Great question. Thanks for asking that. And I'll talk to you guys later. Bye-bye.